The second field to which Article 14 is applied is regarding service matters, and in relation to that, we will discuss certain important leading cases such as UB Madhakar versus Subhas Anand Charan in 2015 by our Supreme Court, and this matter is relating to promotion on merit cum seniority basis. So, as it was pronounced by our apex court, there is a sharp distinction between merit cum seniority and seniority cum merit. In such case, the merit has to be given preference over the seniority, as it was pronounced by the Supreme Court. And the second important leading case, that is relating to compassionate appointment, and the very leading case is Arvind Kumar Tiwari, State of Gujarat, in 2012 by the Supreme Court, and in relation to that, it was pronounced the compassionate appointment cannot be granted on a post for which the candidate is ineligible. So, also we'll go to the next important leading case, and that is in Sachdev versus Maharshi Dayanand University, Rohtak in 2015, the Supreme Court expressed regarding the matter that relating to pension. So the pension is not an ex gratia payment but is in recognition of past service, and the discrimination cannot be made between those employees directly appointed or abject and allocated, and by fixing a cutoff date for the purpose of computation of qualifying service are not the criteria where it would be considered violation of right to equality. And in another important leading case, and that is relating to Ramesh Kumar versus Union of India, and this very case was decided in 2015 by our Supreme Court, and it is relating to the very policy of no work, no pay. So, the very declaration of the apex court is that the principle of no work, no pay will not be followed where the authority is at fault in not considering the case of employee for promotion and not allowing him to work on the promotion post, as it was declared in this leading case, Ramesh Kumar versus Union of India in 2015. And now we'll go to another important leading case, and that is relating to Center for Public Interest Litigation. And this very important leading case, Center for Public Interest Litigation versus the Registrar General of High Court of Delhi, and it was decided in 2015 by our Supreme Court relating to a very post in judiciary. So, if suitable candidates are not found, then the employer is not obliged to fill up the post. So now we'll go to another important leading case, and that is relating to D. Vishnumurthy versus the government of Andhra Pradesh, and it was decided in 2016 by our Supreme Court, and it is as decided on regarding seniority, and that in service jurisprudence as it was declared by our Supreme Court, the right of employee in relation to seniority is vital one. And now we'll go to another important leading case, that is Moni Sharma versus State of Assam, and it was decided in 2016 by our Supreme Court, and it is relating to wrongful deprivation of work and duties. The doctrine of no work, no pay will apply if the employee fails to prove that he or she remained unemployed during the wrongful denial of work to her or him by the employer, as it was decided in this leading case, Moni Sharma versus State of Assam in 2016 by our Supreme Court. And the next important leading case is Union of India versus Lieutenant Colonel P.K. Chowdhury, and it was decided in 2016 by our Supreme Court, and the very field of application of Article 14 is relating to common cadre in service. So it was declared that merely because the incumbents of two posts are placed in the same scale of pay does not determine that such post constitutes a common cadre. And now we'll go to the next important leading case, and that is relating to the very important leading case in the very field of application of Article 14, and that is relating to Uttar Pradesh Sugar Corporation Limited versus Sandraj Singh in 2006. The very application of Article 14 here was regarding equal pay for equal work. So, the very doctrine of equal pay for equal work postulates equal pay for equal work for those who are equally placed in all respects. So, this was the very pronouncement of Supreme Court in relation to this leading case. Uttar Pradesh Sugar Corporation Limited versus Sant Raj Singh, and it was pronounced in 2006 by our Apex Court. And now we'll go to another important leading case, and that is K. Vijayalakshmi versus State of Andhra Pradesh in 2013. The Supreme Court expressed, and this application of Article 14 here was regarding in the field of employment under state. So here it was pronounced that to deny a public employment to a candidate solely on the basis of the police report regarding the political affinity of the candidate would be offending the fundamental rights under Article 14, 16, and 22, Clause 1 of the Constitution, unless such affinities are considered likely to affect the integrity and efficiency of the candidate, or unless there is clear material indicating the involvement of the candidate in the subversive or violent activities of a banned organization. So, as it was declared by our apex court in this important leading case, K. Vijayalakshmi versus State of Andhra Pradesh, in regarding the very application of Article 14 in relation to employment under state. And now we'll go to another important leading case, that is Rabi Nayak versus State of Odisha, and it was decided in 2014 by the Odisha High Court. So here it was relating to filling of more vacancies than notified in the advertisement. So, as it was declared by the Odisha High Court, filling of vacancies over and above the notified vacancies tantamounts to filling of future vacancies and is not permissible in law. And now we'll go to the next important leading case, that is Union of India versus Hemraj Singh Chauhan in 2010. Supreme Court expressed that it was relating to equality in promotion. So, as it was declared right of eligible employees to be considered for promotion is virtually a part of the fundamental right of employees. So, now we'll go to another important leading case, and that is relating to panchayat removal of members, and in that case we will discuss Ram Bedi versus District Panchayat Dulakari, and it was a leading case of 1998 and decided by our Supreme Court. And as it is relating to UP Panchayat Raj Act 1947, Section 14 is valid. It empowers members of the Gram Panchayat to remove the Pradhan of Gram Sabha by a motion of no confidence. It is not unconstitutional, as it is not infringing democracy, neither Article 14. And as our next one is the very important leading case, that is Delhi Transport Corporation versus Mazdoor Congress, and it was decided in 1991, and it is relating to the very field of service, and it relates to such matters as Indian Mazdoor, the Delhi Transport Corporation Mazdoor Congress, which is relating to rule for termination of service. So, rule for termination of service of permanent employee without reason is void, as it was held by our Supreme Court in this important leading case, Delhi Transport Corporation versus Mazdoor Congress. And now we'll look at another important leading case, and that is T. Shyam Bhatt versus Union of India in 1994. The Supreme Court, relating to the application of Article 14 into service, and that is relating to all India services. Second Amendment regulation of 1989, which brings above classification of officers, which is arbitrary and unreasonable, so it is unconstitutional, as it was declared in this leading case, T. Shambhat versus Union of India. And now we'll go to another important leading case, State of Uttar Pradesh versus Rekha Rani, and it was decided in 2011, and that also relating to service matter. So here it was declared an illegality cannot be perpetuated. The claim of for regularization of temporary service cannot be granted merely because some others have been regularized, as regularization of others does not give any right to the respondent, as it was decided in this leading case, State of Uttar Pradesh versus Rekha Rani in 2011 in Supreme Court. And now we'll discuss the two most outstanding important leading case. One is Air India versus Nargis Mirza in 1981, and the second one, that is Leena Khan versus Union of India in 1987, and all this relates to service rules. So, on the question whether service rules would violate Article 14, and in relation to that, the very cases relates to air hostess and deputy chief air hostess belong to the same class in view of the duties performed by them. However, as the Air India Corporation had already adopted the policy of avoiding discrimination, the writ petition had become infructuous, as it was decided in this leading case, Leena Khan versus Union of India, and also in Air India versus Nargis Mirza, and in particular it is relating to service rules, and the subsequently the Air India Corporation's adoption of the policy of avoiding discrimination. So, due to that, the apex court held that the writ petition now had become infructuous. So, this is relating to very application of Article 14, which relates to right to equality in the service matters, that we have just completed the very second important field, that is service matters, and the very application of right to equality and how it could be determined, the arbitrariness or the discriminatory application of those rules or those principles framed by the government or by the legislatures were questioned, either they are being set aside or being declared as null and void, as they interferes in the very fundamental right provided under Article 14 relating to right to equality. And in our upcoming video we'll discuss the very third field which we selected, which regarding the application of Article 14 into other miscellaneous fields, that we'll discuss in our upcoming video.